Welcome back to the county seat. Our next topic is going to look at roads. According to poet Robert Frost, the difference in a road depends upon how many people travel upon it. But in the state of Utah, with so many hundreds of thousands of acres of federal land, the very definition of a road depends upon what land it traverses. Here with the story on B&D roads is Stephen Heumann.
The definition of a road is a way made for traveling between two places, especially distant places, by automobile, horseback, etc. Now, that seems like a pretty simple definition until you take that road and you place it across federal land, in which case the definition becomes more like this. You get the idea.
There are more miles of county roads in the state of Utah than any other kind of road. Classified as Class B roads, those that are either paved or improved, and Class D roads, those roads which are passable and used in a transportation plan but have no regular maintenance or improvements. When those roads cross the 67% of the state that is controlled by the federal government, the focus changes from whether they are improved or not to rather who holds the legal jurisdiction of right-of-way over the road. And that all depends upon when the road was put in service. From 1866 to 1976, any road constructed, created, or used across unreserved federal land, the right-of-way or ownership for that road fell to the states or counties automatically. Those roads are called RS 2477. In 1976, Congress passed the Federal Lands Policy and Management Act, or FLTMA, and from that law's creation date, October 21, 1976, all new roads were to come under the category of FLTMA Title V, in which ownership of the road would fall to the federal agency whose land the road would lie on. According to the new law, all roads created prior to that date would remain a property of the counties or the state. Sounds simple, except for one problem.
Right now, you see, the status quo is there's not a single RS 2477 right-of-way administratively or judicially recognized in the entire nation. The federal government is comfortable in that position because it gives them blanket jurisdiction over every road across the West.
Instead of recognizing RS 2477, the Bureau of Land Management is seeking to get counties to accept a Title V right-of-way. With the Title V, the BLM, not the county, maintains jurisdiction over the road, and the BLM in turn grants permission to the county to maintain it. For many of Utah's counties, it doesn't seem to be a problem. Title V roads work fine with the BLM.
We're having very good success with the BLM. We've been collaborating and working very closely with the BLM.
They've been pretty close. We've got a few roads that we have contested. We have 7 roads that are under contest, supposedly working through the court system.
In some counties, it's not a conflict with the BLM, but rather other federal land agencies that create the problem.
We do have some concerns on the National Forest. There's a new travel management plan that's being developed. In fact, a record of decision was recently issued, and with that record of decision, it will close many miles of roads and trails in Uintah County. The Forest Service stated a few years ago that the Ashley National Forest is best suited for recreation. And so we're disheartened when we find that the mission is for recreation, and then we find that roads are being closed, dispersed camping is being closed, certainly being compromised, being shortened, less opportunity, and so it is a concern to us.
Kane County has more disputed RS 2477 claims than any other county in the state, and given the sparsely routed Grand Staircase Escalante Monument travel plan, it is easy to see why. But the journey to obtain RS 2477 has had more pitfalls and obstacles to maneuver than the roughest Class D 2-track trail. But the many trips to district and circuit court are beginning to pay off, and Kane County sees a chance for all counties to benefit from their efforts to pioneer RS 2477 recognition.
The federal strategy is to eliminate RS 2477 property-based rights-of-way and force the counties to take FLTMA Title V permitted use rights-of-way. In doing that, the federal government has put itself into a box. It has created a case for controversy, a cloud on the title of RS 2477 on virtually every county highway across the West. The county should jump on the opportunity to file quiet title. Quiet title does cost money, but how much and how important is a property-based right-of-way that is perennial in nature?
Somewhere you got to reach a balance in here. The county can only afford so many roads, and so as we've tried to work through the process, we've let some of them fall by with the idea that we can't prove it in court. We've got too many roads we can prove to worry about some of these that are on the peripheral.
So the question is practicality on the ground. Well, one thing we know right now is BLM really has no authority to adjudicate RS 2477 on their own. That rests with the courts. If you're going to have an RS 2477 adjudication, it means you're going to have to go to court, unless Congress changes something. So that leaves you with going to court or the Title V.
Obviously, proactivity is very important because you know what? If the counties haven't had an active GIS program where you've had the opportunity to go out, identify those roads, you've got them on the maps, it may be too late in many areas. So it's extremely important to be very active. Another thing I think is very important is if you think it's your road, you better act like it. Because if you don't think it is, nobody else is going to think it is either.
For the county seat, I'm Stephen Heumann.
With so many issues of access at stake and the broader issue of multiple use of public lands, we will discuss B&D roads in the state of Utah in just a moment. Our guests will be Commissioner Mark Habishaw of Kane County, Commissioner Mike McKee of Uintah County, Public Lands Director Brian Bremner from Garfield County, and Utah County Commissioner Larry Ellertson. Stay with us.